defamation is certainly not a crime. It's just free speech. No one owns a property right in their reputation. It's the reason most people have a tough time understanding how a private legal system would work. Partly it's because of the rise of legislation in the last 100 years. There is no proof that more innovation is stimulated by the patent system. It has a huge cost on society. It distorts innovation. It causes higher prices.
These laws function less as something that protects people and have become more of just a minefield to navigate through.
Hans Hermann Hoppe, he saw a problem with the natural rights defense of libertarian principles. Trademark law is not about fraud. It's about protecting the property right and value of something, which is not a property right. The first purpose of argumentation ethics is to give us an insight into exactly why the libertarian principles that we hold are the only ones that can be justified.
My guest for today is Stephan Kinsella, the anarcho-capitalist patent lawyer. As far as specialized subjects within libertarianism go, there may be no greater authority living today when it comes to intellectual property and the massive problems that copyright and patent laws impose on society. Kinsella certainly seized the reins for me in this episode as he explained in great detail the proper functions of a libertarian legal framework. This is episode 23 of Morgan Meets the Eye, in which Stephan Kinsella explains argumentation ethics, libertarian legal theory, and one of authoritarianism's most overlooked instruments, intellectual property. Hello, Stephan Kinsella. Thank you for coming on to the show. So first off, where can my listeners go if they want to see more of your work?
Oh, my website, stephankinsella.com. And for the intellectual property stuff, which is linked there, is my c4sif.org, c4, the number 4, sif.org. And I'm on Twitter and Facebook at nskinsella.
And first off, I wanted to discuss a pretty pivotal yet fairly polarizing concept within anarcho-capitalist theory, and that is argumentation ethics, which is one of Hans Hermann Hoppe's most well-known and important contributions to libertarian thought. Now, the case that argumentation ethics makes might seem a bit perplexing to someone whose own code of ethics tends to side against libertarian principles, but what I found is that in any case, really, if we break this idea down to its bare bones, the main takeaway here is really that the very act of presenting an argument to another party inherently adheres to libertarian principles. And if the actual content of someone's argument doesn't adhere to those principles, then they're caught in a contradiction. That is, a performative contradiction, to be exact. Now, basically the backstory behind argumentation ethics is that although he was a follower of praxeology, Hoppe wasn't exactly satisfied with the conclusion that Mises drew from it, which was essentially that there was no objective way to justify ethical propositions. So in terms of the actual conclusion that he draws, Hoppe takes the natural rights position, which was laid out by people such as Murray Rothbard in, just to name one example, Ethics of Liberty. But this position, in turn, was founded on the reasoning of praxeology as Mises had laid it out. But going back to the core of argumentation ethics, if someone is arguing for an anti-libertarian position, and if I were to respond to them simply with, well, the fact that you're arguing with me proves that I've already won, then this statement in itself isn't realistically going to persuade a lot of people to give up that position. So that is, to simply say this to somebody is really just asserting a conclusion, and that conclusion obviously needs to be supported by premises. So how exactly would you lay out these premises? Or that is to say, what argument would you provide to support argumentation ethics?
So I'm a libertarian, and my argument for rights is based upon Hans's. I call my theory estoppel, and that's in my book, Legal Foundations for a Free Society. It's based upon the argumentation ethics of Hoppe, and I also agree with his argumentation ethics. It complements my own approach, and I have defended it and studied it for years. The way I view it is argumentation ethics is one of many ways that libertarians understand our principles and our property rights and our justice principles. Some people have justified in the past libertarianism and our principles based upon what they think of as a type of natural law or natural rights theory, and some more in a consequentialist or utilitarian point of view. And then there's like a third by some theorists Jan Lester, who reject both of those, and they go for something called they're anti-justificationists. It's more Popperian. It's called conjecturalism. I think it's a little bit incoherent, but that's another approach. I actually think that's sort of a subset of utilitarianism. But I wouldn't say Hoppe disagreed with Mises on praxeology. I don't think Mises actually ever thought that praxeology was a basis for ethics. He just used it for economic analysis. Mises was more of a consequentialist in his approach to norms and rights and law. I don't think he had a strong argument or foundation or even belief system about what types of things could be justified as rights. He just didn't really explore it that much. Some people call him a utilitarian, but he was actually against utilitarianism in the economic sense because he's an Austrian and believes in subjective value. But I think it's more accurate to refer to him in the way Randy Barnett describes these theories in the introduction to his book, The Structure of Liberty, which is unfortunately online. I mean, not online. But Randy Barnett distinguishes between more of a principled approach to libertarianism, which some people call deontological or natural rights, and a consequentialist approach. And he thinks, and I agree with him, that there's no conflict, there's no contradiction or conflict between a principled or deontological approach to rights and a consequentialist approach, because as Ayn Rand said, the moral is the practical, and the purpose of rules, property rights, is to solve a practical problem, the problem of conflict. And you can justify these rules based upon certain principles, which is what the deontological or natural rights approach does. But you can also justify them based upon how they actually serve to function to solve the problem that they're designed to solve, which is the problem of conflict. So you would expect there to be a convergence between the more pragmatic or practical or consequentialist approach and the principled approach, which we see. And they complement and buttress each other. Now, that's to distinguish consequentialism from a subset of consequentialism, or a type of it, which is called utilitarianism. I think utilitarianism as a ethical theory is definitely flawed. Mises didn't really advocate that. He advocated more what you could call consequentialism, which was that if we share certain values in society, like we want there to be peace and prosperity, we're going to tend to, if you have a little bit of understanding of economics and the way governments and work and the history of all this, then you would understand that that the way to achieve the end that we all favor, which is the values we hold in society, which is peace and prosperity, then the way to achieve that is to have a liberal social order, to have property rights and things like that. So for Mises, the way to achieve that would be property rights, which is not in contradiction to the principled approach either, which views them as sort of inherently good. Utilitarianism is one flavor of consequentialism, and I think it is methodologically flawed because it says that you should adopt rules that do the greatest good for the greatest number, and you sum up the cardinal utility of people, which is all impossible and methodologically confusing, and also leads to abhorrent results. Like, for example, you could argue that a billionaire like Oprah Winfrey, let's pick someone who's not inherently evil, unlike, I don't know, maybe Bill Gates or someone who actually earned their money legitimately. I don't know, Bruce Springsteen. He's a billionaire now from selling his music catalog, although again, copyright entered the picture here, but still, he made his money by performing concerts for people and they like his music. He didn't really steal it from too many people. Anyway, you could say that someone rich like that, if you just robbed them of 90% or half of their wealth and distributed it to 10,000 poor people, that the sum total of the utility gained is positive, because you make 10,000 people far better off, and you don't really hurt a billionaire because being a half a billionaire is still pretty good, right? but the principled approach, and I think a principled consequentialist approach, would say, yeah, but you're still stealing, and that's wrong, and we should have principles against stealing, right? So utilitarianism I would reject, and I don't think Mises adopted it either. It's more of a consequentialist approach. Now, all that said, Hans Hermann Hoppe, what he did was he came up with his own defense of rights because he saw some problems with of course, he's not going to be a utilitarian because he's an Austrian. I don't think he would reject the consequentialist idea that free markets and property rights lead to better outcomes, which is what most of us believe. But he saw a problem with the natural rights defense of libertarian principles, which was that, well, there's two problems with it. Number one, you have the is-ought gap, which means it's the recognition that David Hume pointed out that there is a logical problem moving from a factual statement to a normative statement, from an is statement to a value or a normative statement. And when you say this is the way things are, which is a factual or is statement, and you try to say, and therefore this is what we should do or what laws are good, you're bridging, you're going logically from one realm of description to another. And that requires some kind of assumption, because otherwise you're just inserting your value judgments. So that's one problem with the natural rights argument, is that you just go, and then just what David Hume pointed out, you just go from saying here's what human nature is, and therefore this is what they should do. Is doesn't imply a should. You have to have a lower level value statement or normative statement that you're building that on, which means you have to introduce it explicitly if you're going to not just make an assertion, right? So that's one problem. The second problem that Hoppe noted with the natural rights argument is that, in addition to this is-ought problem, is that human nature is very varied and it's not very crisply defined. There are lots of ways, lots of diverse ways for people to live and values to pursue and different ways of living. So it's hard to get, and the classic example is something that Robert Anton Wilson, kind of a notorious libertarian science fiction writer who's a skeptic of natural law thinking, kind of a non-serious guy in a way, but kind of funny and an interesting science fiction writer. But he wrote this little tract called Natural Law. He was criticizing natural law thinking in libertarian circles. He said, natural law, or don't put a rubber on your willy. So what he did was he made fun of the Catholic Church, which is a type of natural law type of thinking, like you shouldn't use contraceptives, right? Because it's immoral, right? It's just one of these decrees of the religious doctrine that they have, right? But of course, now they would claim that you can deduce this from a series of arguments based upon what human nature is. So they're going from is to an ought, right? And of course, they're introducing mystical prescriptions from the Bible or from tradition or something like that. But he was basically mocking the idea of natural law by using the natural law of the church as an example of how silly it can be. I don't think all the same criticisms would apply to the libertarian application of natural law to natural rights. But still, you can see that this critique is that natural law can only get you so far because human nature is pretty varied and diffuse. And that's one thing Hoppe noted. So what he did was he used his insights from, number one, Rothbard, who had more of a natural law friendly approach, but it still suffered from the is-ought gap problem. That is, you can't really have a rigorous normative conclusion about the way laws should be, what justice is, what rights there are, just based upon the facts about how humans are. You have to introduce some value assumptions, and then that needs a defense. And he drew upon, but he did draw upon Rothbard's radical libertarian critique of the state, and also Rothbard's and Mises's radical understanding of economics, or their Austrian understanding of economics. And he drew upon the work of his PhD advisor, Jürgen Habermas, who is he's still living. He's a very old, very famous continental philosopher, a leftist, brilliant but murky. Actually, Hoppe did not study Habermas's what he calls discourse ethics, which is sort of like argumentation ethics. he didn't study that under Habermas in his PhD program. He studied other things of philosophy. But later on, he actually read Habermas's work on discourse ethics, and also that of his co-European philosopher colleague, Karl Otto Appel, whose work actually Hoppe prefers. He thinks it's more clear. Appel and Habermas developed this argumentation ethics idea, which was sort of getting into the insight that when you justify normative propositions, you always do it in a certain argumentative context where there are two or more people actually involved, and they have certain practical preconditions of existing and dealing with each other, and certain normative presuppositions, which means the basis of having a discussion it presupposes certain things. It presupposes that the discussants are actually discussing peacefully, and they're not threatening each other. Otherwise, it's not really a discourse or a discussion. So there are certain presuppositions of discourse which inform the possible norms that could be proposed and could be accepted as valid in that discourse. So Hoppe took sort of the radical politics of Rothbard, criticized the natural law, the problem with natural law with this Izod gap, drew upon praxeology of Mises and Rothbard, and also drew upon the discourse ethics idea of Appel and Habermas, and blended them together to come up with his discourse ethics. And it's similar to that of Appel and Habermas, except they bent their theory to justify, the welfare state and all this kind of stuff. They weren't rigorous about it. Hoppe was very rigorous, and he also was informed by a radically realistic view of the state and its nature, and also his libertarian theory of exploitation, which is that exploitation is aggression. When people use aggression to harm people, that's what exploitation is. And so his argument is more or less what you described, and what I described now. His argument is that, and so your point about using this argument to persuade people, the purpose is really not to persuade people first and foremost. The purpose is for us to understand, for those of us who are interested in understanding and knowing what is right and wrong, and what theories and what norms and values and rights we can propose and that we can hold up as being justified and defensible, for us to understand that, number one, first and foremost. So the first purpose of argumentation ethics is to give us an insight into exactly why the libertarian principles that we hold are the only ones that can be justified. And when we say that, we mean that can be argumentatively justified. But that's just redundant, because every set of norms that anyone could hold as true or defend as true would have to be those that are arrived at and defendable in argumentation. So, which means they always have to be compatible with whatever the presuppositions of argumentation are. And those presuppositions, which Hoppe identifies, are an assumption or a stance on the part of the parties in any such genuine discourse of peace, and also the practical ability of each one to have survived to get this far, which means to use scarce resources that we have in the world, which is the origin of property rights. So basically, there's these sort of what I call them Grundnorms, following the terminology of Hans Kelsen, a famous legal theorist. A Grundnorm is sort of like a basic value or principle or norm that underlies all discussions that rise above it. So you can think of argumentation ethics as directing our attention to the existence of these necessarily presupposed basic norms of any discourse. And then when someone proposes a norm, you can examine it to see if it's compatible with or contradictory to those other norms. And if it's in contradiction to them, it cannot be justified, like literally, because now you have a contradiction, and that can't be true. And what you could say is, you could say, well, I'm going to keep my socialist norm that I'm proposing, and I'm going to get rid of the basic norms that it conflicts with. But you can't do that, because those basic norms are inherent in argumentation. So you're stuck with those. So you can only come up with higher level norms, like rights principles or legal principles or political principles, that are compatible with the underlying Grundnorms. And once you understand basic economics and the way the state works and basic logic, then you understand that it's simply impossible to justify any set of norms, any political norms or any interpersonal legal norms, except those that are compatible with basically the non-aggression principle and self-ownership. Okay, so that's the core of the argument. Now, how can you use this other than self-understanding and enlightenment and maybe clarifying the theoretical basis of libertarianism and explaining to fellow libertarians, here's why you've always had this intuition. Here's why your inclination to favor peace and prosperity and to favor free markets and private property. Here's why you're right. You're right because your intuitions are correct. And it so happens that the only political philosophy that is compatible with this is libertarianism, because that's the only one that can be argumentatively justified. Now, could you use this persuasively to persuade a socialist? I don't know, but it can give you some insights as to tactics and strategy. So, I mean, quite often what we do as libertarians is we try to do in a less rigorous way, sort of what I just pointed out. We, instead of saying, okay, there are certain arbitrary norms at the base of all discourse. Now, I don't know if they're really arbitrary, but they're necessarily there. I don't think they're arbitrary. I actually think that these norms that happen to be at the base of discourse and peaceful discourse are actually a result of our actual nature as independent human beings acting in a world of scarcity and having been evolved to be sociable creatures that live in society with each other, and that have and that most of us are not sociopaths, and we have empathy with each other. So most of us naturally prefer a world. I mean, there are some sociopaths out there that don't care about any of this, and they don't really prefer that their neighbor have a good life, and they don't value their neighbor's life at all. For those people, we can't reach them with argument anyway. We only have to deal with them with force and ostracism, and just be careful. Ultimately, you have to regard them as like an animal, like a dangerous animal, and treat them, as Hoppe says, as a mere technical problem. But you could use an approach similar to this understanding of why libertarian rights are justified and why they really can only be justified with this this sort of improvement of the natural law approach. By the way, so the improvement is Hoppe, in a sense, you could say he rejects natural law and natural rights. But what he really does is he says he identifies a problem, which is the is-ought gap, and he finds a way to overcome it by. So he views his argument as sort of like natural rights rightly conceived. So it's a type of natural rights thinking. But the way you arrive at it is not to say human nature has these features and therefore we should do this. Instead, he says people come together to justify norms, and when they do it in a certain context which has normative presuppositions as part of the nature of argumentation, and therefore there's only certain types of high-level norms that could be ever argumentatively justified successfully that are compatible with those norms. So that's his approach. But what you could do is you could say, listen, I'm talking to, I don't know, a Democrat in America, and most of these people are not malevolent misanthropes. They actually think that they want good things for their fellow citizens. They just misunderstand the means to achieve it. They don't understand economics. Number one, they're usually illiterate about economics, and they're wildly naive about the true nature of the state. So what you can do, though, is you can say, listen, we all want peace and harmony and prosperity, right? And they'll usually agree with that. So you right away, you don't even have to justify these grund norms that everyone already agrees with. What you do is you establish a common base, and then you go higher and higher. You see where you disagree, where you diverge, and usually they diverge in the fallacious notion about the necessity of the state, which is tied in with the idea of the public goods idea. So basically, they believe that they believe in the core libertarian norms that underlie the traditional private law of the Roman law and the common law, which is basically everyone owns themselves, which is why murder is not usually permitted by private individuals anyway. And they believe in private property rights, which means theft is not permitted. So most people believe that, but they also believe that there are certain public goods problems or problems in society that cannot be solved in a private order, a private peaceful order. So they think there's a need for the state, for some organized collective to come in and to have an exceptional ability to violate the norms that everyone else is subject to. So most people are like soft libertarian, but they're willing to make exceptions for the state because they think it's necessary. And they also think it's just because they think it's necessary. So what you could do is you can say, okay, well, let's examine why you think that's necessary and that's just. And you can make some progress over time, but that's just normal activism and civilized discourse with people. Whether or not you can say, and by the way, you should read chapter 2 of Hoppe's Theory of Socialism and Capitalism. This will really put it on a solid footing for you. I don't know if that's usually a good tactic, but if someone asks a question, well, how do you know all this? You can say, well, there's actually a pretty rigorous defense of rights if you want to go further. But really, we already agree on the basic values. Now we have to discuss the proper means to get there. And of course, as libertarians and those of us who are anarchists, which just means that we believe that we're libertarians who oppose aggression on principle, meaning we oppose it in all cases without exception. So we oppose private aggression or private criminality, which is why we all favor the private prohibition by law of aggression, theft, murder, things like that. But we also oppose public criminality or institutionalized crime, which is what the state does. So we just don't make exceptions for the state. So we oppose all aggression on principle, and we just don't make exceptions because we think we understand that it can't be justified. We understand it can't be justified because we have a principled approach. Because if you appreciate Hoppe's work, you understand why only that approach can be justified. So that's sort of succinct summary of the way to look at all this.
Just to make sure that I understand what you're saying correctly. So it seems as though Hoppe has taken the conclusion that was drawn by the natural rights, advocates, but has supported it with completely different reasoning than they often used. Reasoning that was more in line with Mises, for example.
I think you can put it that way. So he recognizes that in society at large, there is widespread agreement on certain wide shared values. Most people are not misanthropes and they're not sociopaths. So among people in civilized society, people tend to have at least they at least value other people's lives. They might value there's more, but they still have some value. They have some empathy, and they also prefer to have cooperation and prosperity among their fellow citizens. And then libertarians, of course, have a more rigorous and principled and exceptionless understanding of how to achieve these results using private property rights and rule of law and self-ownership and things like that. So what Hoppe did was, so you could say it's a new approach or completely new approach, but in a way it's not, because I've got a collection of quotes in my I think it's in my book and on my website. This way of thinking has a pedigree for decades and hundreds and maybe thousands of years of, like, even John, maybe thousands is pushing it, hundreds, let's say. Even in John Locke's work and work of other more contemporary thinkers, lots of libertarians, lots of them who think of themselves as natural law theorists or natural law thinkers, and some who are more utilitarian, they all sort of get at this intuitive insight, which is that if you don't respect, there's a reciprocity in rights, and libertarians always see this intuitively. This is inherent in the very idea of the reason we oppose aggression, is that we say you're entitled to use force or to do anything in the world, except you can't initiate force against someone else's body or their property. But if someone initiates force against you, then you're entitled to respond. Now, so it means there's a symmetry there. So force can only be used in response to force, right? But it can be used in response to force, right? So that basic insight sort of implies that there's an intuitive logic to the idea that you can do something that's similar to what was done to you, right? Like you're not normally justified in taking someone's property or hitting them in the face, but if they're attacking you, you can go do back to them what they've done to you, which is what I elaborate on in my estoppel theory, which, as I mentioned earlier, is sort of like built on Hoppe's argumentation ethics. So in John Locke and in other libertarian writers, they often write something like, well, if you don't respect other people's rights, then you don't have any right to insist upon the legal system protecting you, which is a way of saying you can't complain if someone uses force against you if you started it, which is just another way of saying that the initiation of force is what's wrong, but responsive force is not wrong, right? So that sort of that intuition, which, by the way, is shared by even non-libertarians, but some classical liberal thinkers and just philosophers in general, is kind of what Hoppe builds on, but makes it more rigorous. Like he puts it in more of a rigorous argument to explain exactly how all this comes out. So I think Hoppe is building upon fairly common sense and easily defensible notions, which a lot of people have shared over the centuries, but putting them in a framework in a libertarian context and making the argument more coherent and rigorous.
What I've heard you alluding to across your answers is basically the concept of self-ownership, which is really one of the most, I would say, a central, perhaps one of the most central ideas within Hoppe's argument. We have to be able to use our physical bodies in order to actually make an argument. Nobody can even initiate an argument otherwise. For example, if my ability to make an argument directly depends on upon you respecting my private property rights. If, for example, if you assaulted me or grabbed me by the jaw in an effort to hold my mouth shut or seized my fingers so I couldn't write or type, then I wouldn't be able to make my argument in the first place. But as far as self-ownership, though, there are some people out there who might claim that using something should not be conflated with owning it. In fact, even the libertarian thinkers Robert Murphy and Gene Callahan have made a similar point in a paper responding to Hoppe's argument. Now, of course, as libertarians, we do recognize first use as a means of owning previously unowned objects, but there are some people out there who might not recognize this principle as an objective reality, or they might make claims about perhaps parents having established first use over the child's body, or even denying the concept of free will altogether. So basically, what case would you make to prove that we do in fact own ourselves? And how would you respond to the rebuttal that the use of our bodies does not actually prove self-ownership?
Well, I think that's actually correct. The use of our bodies doesn't prove self-ownership, and that's actually one criticism Hoppe makes of a similar argument by Alan Gaworth, which is similar in some ways to the discourse ethics of Appel and Habermas and now Hoppe. And Gaworth is another lefty philosopher who used his theory, which he calls the principle of generic consistency, to argue for, again, kind of democratic socialist welfare rights. But his student, Roger Pilon, who's a well-known libertarian theorist, who studied under Gaworth, sort of like Hoppe studied under Habermas, he used the Gaworthian idea to argue for libertarian rights. But the problem with it, as Hoppe points out, is that the core argument of Gaworth is that all action is conative, which means it has certain presuppositions, which. But Hoppe points out that that's not true because, first of all, you could have Crusoe alone on an island, and he could possess things and use things as means, but it doesn't mean he's claiming ownership of it because there's no other people around to have ownership with. That's why Hoppe points out that it's not action in general that is conative or that has presuppositions, because you can act without making any assumption, but it's when you enter into argumentation to advance a proposition. When you do that, that's a subtype of action which does have argumentative presupposition. So that's why his thing works. So he actually recognizes that that it's not action itself or using things that means you're making a claim of ownership. But what he does say is that in argumentation, so you pointed out, like if you're grabbing someone's jaw, it doesn't respect their rights and they can't actually argue. Well, first of all, as a practical precondition of what argumentation is, whether or not you're violating someone's rights, it's simply not an argument. It's not a discussion. It's not a discourse if you're coercing someone. So if I say, you better accept my argument or I'm going to shoot you, then that's not a genuine discussion. For it to be genuine, you have to have already sort of accepted the stance that that we both have the non-coerced freedom to accept or reject a proposition from the other, and to walk away if we disagree. In other words, there's the right to disagree. So that presupposition means that for it to be genuine discourse, you have to assume a property right in the other's body. You have to assume that you can't violate it. So that's where you go from merely recognizing possession or bodily use of something to the other person having to respect your right to do it. Because if they don't respect your right, they're effectively threatening and coercing you, and it's not really discourse. Now, in my work, by the way, my book, which is free online, but people can order it. It came out last year. It's on my website, Legal Foundations of a Free Society. I've got a chapter in here extensively criticizing the approach of Murphy and Callahan when they disagreed with Hoppe. I think their critique is off the point. I don't think Hoppe does conflate possession with ownership. He recognizes the distinction, and I make that distinction many times in my book. The way to look at it is possession is factual. It's a factual thing, and it can apply to Crusoe alone on the island or someone not making a rights claim. It's the essence of human action, is that humans are actors who have ends in mind, and they employ scarce means or resources as tools to achieve those ends, right? So to use a means you possess it and you manipulate it and you grapple with it, right? It's an extension of yourself, which is one reason the word property emerges, because a thing that you're using to achieve your goals, like clothes or a spear or some kind of tool, it becomes a property of yourself, because it's sort of like part of your identity. So we that's why we call things property. Like, that car is my property. As I point out in my book, that's an imprecise use of the word property. It's better to say that I have a property right in a resource, or I have possession of a resource. But in society, when we have people that recognize norms and values and rights and law, that's when you have the distinction between possession and ownership. So self-ownership, to be clear, the term self-ownership is itself problematic, because it would be better to say body ownership, because the body is the scarce thing that there can be dispute over. Someone can try to shoot your body or have sex with it or use it without your consent, right? And there can be physical clashing between people's bodies, which is why in a genuine argument, people don't do that. And by the way, Hoppe in his argument points out that not only is there a presupposition that each person respects the other's bodily integrity, which is a form of recognizing property rights, and not only would it be self-contradictory for one person to recognize property rights in his own body but not in the other, which is what you would have to do to argue for domination or slavery. You would say that I have a right to myself, but you don't have a right to yourself. The problem with that is that runs afoul of the rules of argumentation and universalizability, because if you're coming up with a proposition, you have to give a reason for it to try to persuade the other person. You can't just be arbitrary, and you can't just say, well, I'm me and you're you, so that's why it's right for me to hurt you and you can't hurt me. That's not universalizable. It's particularizable, and it's not an argument. It's not giving reasons. And when you don't give reasons, it's the same as being arbitrary and making assertions, and it's the same as fighting and not really having a genuine discourse, right? But the other point is, arguing is not just a free-floating affair with two people with bodies living without a world around them or context. They actually have to have standing room. They have to be somewhere. So they're actually using physical space on the earth. And they had to have lived to get there. They had to use physical resources to get there. They had to eat food, homestead things, get things by contract, be free to use their labor. So that's where you go from self-ownership, which is your body right, as an extension of every person having a body and owning their body also has the right to homestead and own unowned resources in the world, right? That's how you get from one to the other. As for the parent issue, I actually discussed that in detail in chapter, I think, 4 of the book I just held up, where I talk about, and I draw upon Hoppe's reasoning there too, why, how we come to own ourselves. And it's the one thing that I argue in my book, and I think it's kind of unique to my approach to things, is that we have to make a distinction in rights between body ownership, or what some people call self-ownership, and ownership of other things that we acquire. And by the way, the problem with the term self-ownership, when I use it as a synonym for body ownership, because the body is really the only thing you can own. When you own your body, you own the component parts of it, like your arms, your heart. You also own your brain, right? But the concept of brain is a physical, scarce object inside your body. It's distinct from the concept of your mind, for example. And the concept we have of you being a person, your personhood, your personality, is distinct from your corporeal, physical body. So you own your body, but you don't own, and you own your brain, but you don't own your mind. Your mind is just it's a non-material existent that we have a concept that's useful, right? It's related to your brain, but it's not your brain. A dead body has a brain, but it doesn't have a mind, for example, right? If you believe in souls and all this stuff, you could say someone has a soul, but again, that's part of their mystical personality or part of their identity, but it's not part of their physical body that something property rights would attach to, right? So that's one problem with the word self-ownership. But the point is this: the basis for your ownership rights in something that you acquire, according to Hoppe's theory and my understanding of libertarian principles, is that no one can deny the need and the rightfulness of people being able to use scarce resources in the world. Otherwise, we would all be dead. Which means that there has to be a first user of an unowned thing that was never used before. If there's a first user and we believe in these norms against that are promoting peace and that oppose conflict, then that means that the first user has a better claim to it than anyone else, which means someone else can't just come along and use force to take it away from them, right? Otherwise, their possession would be insecure, and we would have a war of all against all again. This is exactly why homesteading is the basis of all property rights in external resources, that is, in things that were previously unowned. So the point is, if I am a self-owner and I own my body and I roam around the earth and I come across an unowned scarce resource, if I start using it, no one can complain. If they could complain, that would mean they're the owner. But by assumption, it was an unowned thing. And if they take it from me later, they have no good claim to it because they came second. I'm the first owner. This is why owning things, no one can complain about it because they're not the owner. There's no one that's offended or harmed by homesteading actions. But that homesteading action presupposes an actor. That is a person with a body, a person roaming around the earth that has control of their body. That person already is a self-owner, and they're not a self-owner because they homesteaded their body, because that makes no sense. To homestead something, you have to already possess and be in control of a body that you already have ownership of, right? So the basis of rights in your body is not the same as the basis of rights in things that we acquire. In external, unowned, inanimate things that we acquire by homesteading or by contract from a previous owner, for those things, we can sell them because we can get rid of the ownership. We can acquire these things and we can deacquire them. This is why selling things that we own is part of our rights as owners. It's one of the things you can do as an owner. If I own a thing, I can use it and I can allow someone else to use it. I can loan it to them, or I can deny them the right to use it, or I can sell it to them or give it to them as a gift. I can do any of those things because I'm the owner, but because I acquired it, I can abandon it in effect. This is what I discussed in chapter 9 of my book about contract theory. The same is not true of our bodies. The reason we own our bodies is not because we homesteaded our bodies. To say that confuses the reason that a self-owning, self-acting human actor has the ability to acquire unowned resources in the world is to confuse that process with how we come to have rights in ourselves. To think that the same process is the reason we have rights in our bodies is either nonsensical or it's mystical. It's like you imagine this heavenly realm of souls, the Christian God or something has an immortal soul, or he makes a new soul. I don't know how it works. And this soul, it's like a ghost that comes down and jumps into the mother's stomach when she conceives, or when the baby has quickening or something. But the point is, there's like a human body that this soul jumps into and starts controlling. And I guess you could say he homesteads it. But this is not rational thinking, and this is not what libertarianism requires, because you don't have to be a Christian or religious to justify political norms, right? It has to be a rational theory. And anyway, the theory makes no sense. Instead, as Hoppe points out, what's common between our mode of ownership of external resources and our mode of ownership of our bodies is that in both cases, the person claiming the ownership of this resource has the better connection or the better link to it than anyone else, which is what you have to have a working property system that prevents conflict and solves the purpose of what property rights are there for, which is to prevent conflict. And so in the case of me having a body that I control and acquiring an unowned resource in the wilderness, the direct link is the way I transformed it and established a physical connection and a record between me and the thing. I put a fence around it. I transform it. I possess it. There's some actual evidence that I have a connection to this thing, and now no one else can take it from me without my permission. So by my homesteading action, I have acquired ownership of that thing. So I've established a direct link that gives me a better claim to it than anyone else. Or if a previous owner gives it to me by contract, now I have a better claim than anyone in the rest of the world, because I have this chain of title to someone who gave it to me. And I have a better claim to it than the guy who sold it to me, because he's relinquished his title. So it works out nice and neat. But in the case of your body, the reason that you have a better claim to your body is because of your direct control of it. That's what Hoppe points out. Because you're the one who can control your body, and anyone else's control of your body is indirect. It's not direct. I can control my arm by will, directly. That anyone else to dominate me and claim ownership of my body, they can only do so by coercing me. In effect, they can only persuade me to do what they want by threatening to use force against my body. That's why their claim is always inferior. And not to mention, their claim would be contradictory, because for someone claiming to have the right to indirectly control my body by coercing me is effectively saying I have no right to my body. But they're claiming a right in their own body. Okay. And the only way that you can have a distinction like that that's justifiable in argumentation is if you give a reason. Right? Now, if you're some kind of racist or sexist and you think, well, the white man is superior to the blacks, or men are superior to women, so I have the right to enslave you, or I have the right to treat my woman as my property and to beat her, or something like that. Okay, you have to offer a reason for that distinction. Now, for example, we might offer a reason like that in the case of animals. In fact, we don't try to reason with animals precisely because they can't reason with us, right? But with another human you're having a rational discourse with, and you're trying to find a norm that we can all agree upon, the basic presumption is that we're equally situated. The only way you can come up with a rule that's not universalizable, it has to be universalizable, it has to apply to everyone equally, unless you give a good reason grounded in the nature of things to treat people differently, right? Which is why, by the way, Murphy and Callahan are wrong in their critique of Hoppe. They don't understand, because what they do is they pick apart, they say that, well, it's possible for a slave owner to argue with his slave, but yet he still owns a slave, and so therefore it's apparently not an argument of contradiction. What Hoppe would say is, well, that's actually not true. The slave owner, to the extent he's engaging in genuine discourse with the slave, is actually contradicting himself by supporting the rule, I can dominate this guy who's done nothing to me, because unless he can come up with a reason grounded in the nature of things to distinguish between them. And by the way, you can do that in certain contexts. So, for example, if someone commits aggression against you, now you're entitled to use force against them in defense, or even to capture them to get some kind of restitution, or to put them in a, to incapacitate, prevent them from continuing the harm or from hurting your family or attacking you. You can do things to that guy. You can put him in jail, for example, right? You can hold him in a prison cell on your property where you catch the guy, or you defeat him in a fight until the law arrives, until he goes off to being sentenced or trial or something like that. But for that duration, you could actually have a conversation with the guy. And if he says, well, you're being a hypocrite, you're being contradictory by claiming rights to yourself, and yet you're dominating me, in that case, I could say no, because there is actually a distinction I can point to grounded in the nature of things, and that is that you actually committed an act of aggression against me. So now I'm entitled to do something back to you to defend myself or to get some restitution or something like that. So when someone commits an act of aggression, they do change the status of things, and that fact can enter into discourse, and then you could justify dominating that guy. And so when you have a conversation with him about the norm, you're actually not contradicting yourself, and you're not being hypocritical.
I definitely, appreciate the thoroughness of addressing the concerns raised against argumentation ethics. And in regards to Robert Murphy, I do know that he has made a certain argument against it within one of his papers. I believe it's actually that very same paper with Gene Callahan, where basically he says that he creates an example where if a man goes to a movie theater and he sees a sign that says to remain silent during the movie, and he ends up creating an enormous commotion while the film is playing, and then as a result, the theater's employees respond by, forcibly removing him. What if he, in turn, demands that they explain the piece to him? And, basically they allege that if they don't provide him with an actual debate explaining this, is this some kind of a performative contradiction? Because after all, if you have to remain silent during the movie, you
right.
can't tell the customer your own argument. So, this example is obviously very silly, but Murphy's point is that rules are not inherently indefensible if applying that rule renders debate impossible at a particular moment in time, which would be in this case while the movie is playing.
Yeah, and that goes along with the slavery argument, like that Hoppe's argument is flawed because you could imagine a slave owner arguing with the slave, and it's possible to have an argument. But we would just say that means that the slave owner can't justify his domination of the slave. And it gets to another confusion about the purpose of argumentation ethics. It's not. The purpose of argumentation ethics is to show which types of rights are justifiable in argument. It doesn't mean that. So if you and I if we look at this as libertarians and we understand that people have a justified claim in scarce resources that they own, then they own those resources because of that principle being justified. Once you own a resource, that means you can use it as the owner. So if you're the owner of a movie theater, you have the right to not permit to eject people who are using your property. You don't have to let them use it. Doesn't mean you have to sit there and have a debate with them about it. The point is, if you have a property right, then is it justified? And the argumentation ethics shows us how to understand and to determine which claims are justified. It doesn't mean that they have to be justified. It doesn't mean everyone has to be an arguer and to engage in argumentation to defend. And again, this is the other problem with the idea that, even if you're right that it's contradictory to assert socialism or something in the course of an argument because it contradicts the presuppositions of argument, that only applies to the argument itself, and as soon as the argument's over, it's anything goes. That's actually misconceives the purpose of argumentative justification. The whole purpose of argumentative justification is to determine what rights we have in general, like when we're walking around the earth and interacting with people and using resources. So that's what the discussion is about, and that's the point. When we say that people have property rights in things, it's all the time. and we know this because if we imagine an argumentative scenario when we're trying to examine which rules could be justified, only that set of rules could be justified. It doesn't mean that they have to be justified during the duration of the argument or something like that. But anyway. And by the way, Hoppe doesn't talk about this very much. He stopped talking about it pretty much after the flurry of articles he wrote debating this issue with many other libertarians, most of whom disagreed with him because it was basically poaching on their turf and criticizing their previous approaches, their utilitarian or their natural law approaches. There was a whole symposium in Liberty Magazine in 1988 where he came out with this, and about 15 libertarians all violently disagree with him, except for basically Rothbard. But he quit talking about it. But I want to say about 6-7 years ago, maybe 2015, in Turkey at the Property and Freedom Society thing, which is an annual meeting he founded, he addressed all the criticisms of his argumentation ethics that had built up in the last, say, I don't know, 15 or 20 or 25 years. And so I would recommend anyone take a look at Hoppe's fairly recent response to critics of argumentation ethics, where he deals with people like Murphy and others and in the criticisms of it.
I don't mean to essentially belabor the point by throwing you these different arguments against argumentation, but one in particular that I find rather interesting, and one that I also think tends to misrepresent the issue as well to an extent, is that, for example, I've heard, from for example, if we cite Wesley Newcomb Hohlfeld, the legal theorist, he broke the concept of rights down into subcategories of liberty rights and claim rights in his work, Fundamental Legal Conceptions. So basically, in this case, a liberty right would mean that gives me the ability to do what I choose, but there are in turn claim rights which give others restrictions on what they may do to me or to you in this case. Now, as libertarians, obviously, we keep those claim rights down to basically any direct harm upon our physical bodies or theft or any real transgressions against our property. But basically, in the years following Hohlfeld's framing of rights in this manner, there has been among some self-proclaimed libertarians that argumentation ethics is actually invalid because there's allegedly no performative contradiction after all in taking these certain arguments. Specifically, somebody might have a liberty right to make a certain argument, but then they might turn around and say that their right to have their bodily autonomy respected in making in such an argument is a claim right. Now, to be clear, I don't agree with this rebuttal, and I do have some responses of my own to it. However, you have a lot more legal expertise than me, and I'm curious on how you would respond to such a case. So,
I mean, I think here's the way I look at it. We have to recognize that libertarianism is a very radical doctrine, okay? So we have to be careful not to just rely upon conventional or mainstream legal frameworks, because there's a lot of loaded baggage in these approaches. You can get some insight from these thinkers. I tend to ignore people like Hohlfeld and this liberty versus claim distinction, because I've never found it. We're almost starting from scratch. We're saying, look, we talk about non-aggression and the non-aggression principle and self-ownership rights. That's really all we need to do to establish the basic principles of libertarianism. All these fancy nuances that law professors and legal theorists would come up with to clarify and make the law more nuanced, they're going to do it in an ideal future society based upon a rational basis of law that develops on there. And we can't assume that, like the common law and the Roman law, which I think in their principles are largely compatible with our principles, but not always, right? I've never seen the utility of this claim liberty distinction. I think it's frankly kind of sophistry. It's just a way to muddy the water and to use a conventional legal analysis, which is basically positivist and accepts the state and all this kind of stuff, and imports these presuppositions of legal theory, conventional legal theorists, in some kind of convoluted argument, which is effectively what they're saying is. So this is what I find interesting by these so-called libertarians who cite Hohlfeld and these convoluted arguments that no one quite understands. I think they're all make-weight arguments, and they're tendentious. But these guys are supposedly libertarians, which means they presumably believe in libertarian principles, more or less, for some reason. Now, they apparently have no reason for it because they can't give a good reason. I mean, I guess they would say they're utilitarian and something, whatever works, or something like that. But the point is they actually favor, for some reason, roughly the same libertarian principles that Hoppe does and that you and I do. Why? Is it just arbitrary? So what they're saying is, oh, I agree with the libertarian argument, but I think Hoppe is wrong to say that. I mean, what does Hoppe say? Hoppe says that it's impossible to justify socialist norms, which is another way of saying libertarian principles are justified. But the libertarian apparently believes that libertarian principles are justified and that they think socialist norms can't be justified. So what do they actually disagree with? Or they disagree that Hans is wrong? Do they think that they're libertarians but socialist norms can be argumentatively justified? So you could justify a norm that says I can hit you, but you can't hit me, even though we also are agreeing not to hit each other when we're engaged in peaceful discourse. I just don't see how someone who's a libertarian I can see how a non-libertarian can disagree with Hans because they actually they make exceptions. They think that usually they're against aggression, but sometimes they're willing to condone it because they're not principled libertarians. But if you're a principled libertarian, you actually believe that violence can't be justified, which is what Hoppe is saying. He's just showing why. He's showing why because if you look at how anything has to be justified, it has to be done in a peaceful context, and that's why the attempt to justify these norms we all agree is not justified. They fail. They fail because they're incompatible with what we always adopt when we're engaged in peaceful argumentation. So I think it's just odd that people are so worked up about Hoppe's attempt to show what they already believe is true is true.
Right. Yes, and it's very interesting too how whenever somebody is caught in some type of a contradiction such as this, the first step is to immediately say, well, we can break this down into group A and into group B, and suddenly it becomes almost a type of an unnecessary distinction to be making in the first place. It's almost as though the distinction serves the purpose of being able to get away with a certain contradiction.
Yeah, I think that we need to establish the basic libertarian principles, which, as I said, I think the core principles are self-ownership and the right to homestead unowned things and to acquire them by contract. That's the basics of all private law. Now, as you have a more developed libertarian order and legal system, then the legal theorists can come in. They might make distinctions about types of ownership, leases versus this. But in the basic case, trespass is the use of someone's resource without their permission. Okay, in the future, we might have a more nuanced legal system where now we have second-degree murder and first-degree murder and breaking and entering and assault versus battery and lease versus contract and, all these nuances which a legal system would develop. And maybe the way the legal system has done it already is roughly the way we could expect it to develop, but we can't assume that because we're a radical philosophy. In a way, we're starting from the ground up, but we have to be humble about it, and we have to admit that we don't know all the nuances or the contours of a fully developed legal system, and we don't know for sure whether the way that the positive law, that is the common law, the Roman law, and the English common law, the private law that we have now, we don't know that that's exactly the way that all that is compatible with our libertarian principles. So you can't just bring in these you can't bring in these outside classification systems that are done by legal scholars operating within basically a positivist, non-libertarian statist framework where they take lots of things for granted that we don't take for granted when we try to justify the basics of libertarian principles.
And on that note of actually setting up a new libertarian type of law, that does lead me into another subject I kind of wanted to change gears towards for a minute. So I'm seeing something of a line between argumentation ethics and our legal system itself. So to give one example, there is a legal principle, and might I add, I think it's one that is not enforced sufficiently under the state, and that principle is estoppel. So yes, the concept of estoppel prevents someone from saying or doing something that goes against one of their previous words or actions, which seems to be very much in line with the principle behind argumentation ethics. It rejects performative contradictions. Now, in light of this, what exactly would you say is the relationship between argumentation ethics and not only estoppel, but really our current legal system as it exists in general? Do you think it has any, sufficient influence upon it? Or do you think that our current legal system is too thoroughly divorced from the idea or from the principle behind it?
Well, I think that the private law, which developed in the Roman law and in the common law, um, is largely compatible with the core libertarian principles that I mentioned earlier, um, uh, and it appears to be largely a reasonable attempt to put meat on the bones, to flesh out a working legal system. But there are exceptions where it's not, and it's riddled with exceptions. First of all, these systems were not totally without state involvement. They were part of a certain type of state. And then over time, especially in the last century, there's been an enormous amount of legislation, which created by state legislatures in the continent of Europe and also in the British English American system, which has gradually submerged the core evolved private law principles, which again you could argue are largely compatible with libertarian insights. So that those are getting more and more buried and submerged and overwritten by positive law, which there's no basis for thinking that it's compatible with libertarian principles. Now, you mentioned estoppel. Estoppel is, again, what I mentioned earlier. That is the word I use to describe my own theory of rights. And I came up with it because as I learned more about the law, and the law has this ubiquitous principle of estoppel in it, in the common law, right, and in the Roman law, which was used as a basic intuitive principle of justice by judges and jurists in cases where they were trying to do justice, and when they had a dispute or someone seeking a remedy, um, when the justice noticed that one party was seeking a remedy that was based upon a claim that contradicted some action they did earlier, then one easy way to achieve justice in that case was to say, well, we're not going to honor your claim, like for contract enforcement or something like that, because it's incompatible with what you did earlier that the other guy relied upon. So it would be unjust to do that. So there's sort of an intuitive understanding of the necessity for consistency, right? And to avoid contradictions, people should be consistent in what they say and the stance that they maintain. And I realized that insight was similar to the logic of the non-aggression principle, and I thought, well, I could use that to show exactly why the libertarian view that aggression is unjust is justified, because ultimately what we say, as I mentioned earlier, is that force may not be initiated, but in response to force, you may initiate force. There's a symmetry there, and the reason is because if someone commits an act of force against you, they use your property without your consent, they're acting on the rule that it's okay to use people's resources even if they object. So if the victim of that act of force responds with force to defend himself, then the aggressor has no right to complain, because he would be contradicting himself, because he's already laid down the rule. He's basically agreed, here's the rules we're gonna play by, that we can use each other's resources without our permission. So then he can't say, well, you can't use force against me because I don't consent. It's like, well, but you already said you don't think consent matters. So that's the insight I had, and then I realized I could use that insight to extend the legal principle to a libertarian principle, and use that to complement Hoppe's argumentation ethics. Now, what I would say is, from that approach and from Hoppe's argumentation ethics approach, the way to look at the state and state laws is that just like we looked at the example of a slave owner arguing with his slave, he would be unable to justify his claim to enslave the slave. He could physically do it, but he can't justify it. Likewise, Hoppe would say that the state is a criminal organization which basically enforces the law, monopolizes the law, and applies to ordinary citizens the private law principles that you can't steal from each other, you can't murder each other, but it makes an exception for itself. Like it's a separate set of rules for itself, which again means that they can't justify their unique position. They can't justify their special status. They don't have the right to do things that they say your average person can't do. So that's why state laws are unjust, because they can't be justified. So I think he would say that the entire state enterprise is a walking contradiction, which means it's just an unjust criminal enterprise.
When we start implementing the concept of estoppel under the state, we start seeing something of a trend here where the state, it becomes very awkward for the state to really start implementing this in any consistent manner. And for this reason, I find it odd enough that the legal system seems to be one of the hardest facets of society for people to imagine privatized. If there are multiple competing courts, for example, people might ask, why would anybody accept the verdict of a court that they don't happen to agree with? What's going to stop them from seeking a second or third or fourth opinion, and so on and so forth? And prisons are an even harder, concept for people to understand. For example, how can punishment be made into a voluntary decision? They'll say, I personally think that the problem with this line of thinking is that it preserves the exact form of our legal system as it currently exists and simply changes these forms from the forceful monopoly that we currently have to multiple competing agencies. And while I do consider this to be an improvement, I don't think it addresses the central issue, which would be the actual form, the shape that exists of our legal system. So instead of being sent to an institution against one's will for a predetermined amount of time in order to rehabilitate that person, there are in fact other approaches to preserving social order and security, as well as justice, that don't rely on the simple get arrested, get held in jail for a while, speak to a judge, get found guilty, then go from that jail to prison process. And that's basically what I want to ask you about at this time. That is, how can courts, police, and prison be privatized exactly? And how would external punishment work if we're speaking in a voluntarist society?
Well, and opinions vary upon that, even among libertarians. I think the reason most ordinary people have a tough time understanding how a private legal system would work, partly is because of the rise of legislation in the last 100 years. And, 500 years ago, 1,000 years ago, 300 years ago, people thought of law as more of a scientific working out of the principles of justice by courts in response to disputes between people, where the judges were trying to do justice between the parties and find the best result, to minimize conflict and to respect the developed legal principles that people have been relying upon so far. But when legislation started becoming more and more of a dominant way of so-called making law in the last 100 years, which happened after the rise of democracy and the rise of the administrative state, at this point, and especially in America with the Constitution, so people start thinking of laws as not what is not being discovered by judges and being compatible with kind of our nature and what's naturally fair, but it's just whatever the government decrees, right? So so they think of laws as things that are written down and announced by some committee, like a legislature or parliament, or the founding fathers, when they wrote the Constitution. This is just something written down. So people start thinking of law as words written down and issued by the sovereign, which is the state. And then these rules have no necessary connection to justice. And in fact, they have less connection to justice because they're arbitrary. Whether you can drive over a speed limit, or what the age of majority is, or whether it's a crime or not to have practice a certain religion or read certain books, or use pornography, engage in gambling, consume drugs sell drugs, that kind of thing. So over time, people start losing. They don't think of law as having much to do with justice. It's just what the government decrees. That's why. And then this reasoning also is similar to that of many, even some minarchists who believe in minarchy, and like objectivists. A lot of them actually ideally believe in a one world government. Like the idea of having 200 separate jurisdictions in the world drives them nuts because it's not uniform. So logically, they should favor one world government because that's the only way to have an objective law across the whole world. Most people don't believe in about having a one world government, even your average citizen. So they understand that there can be disputes between people in different countries, even though there's not a single legal system. So they understand that there's some higher law or international law or customary law or treaty law or contracts between people. So they understand that you don't have to have one legal system. So we just say, let's decentralize even further. Let's have 50 states, which we do in the US, maybe go by county, maybe go down to the individual level, maybe go by contract alone. If you got rid of the idea that law has to be issued by a legislature, it would be easier for people to understand that law can develop in a common law system, in a decentralized, evolved legal system, and that it could be different from region to region or country to country. If we decriminalize so many things that have no basis being criminalized now, like get rid of the drug war, for example. Don't have, don't make certain things. Only make illegal what is a natural, what we call a malum in se crime, like basically only trespass against people's property and their bodies. Murder, rape, theft, trespass. Only make those things illegal. Respect property rights as defined by contractual arrangements and contractual transfers. That's the core of what a legal system would do. And if you did that, there'd be the jails would be 95% empty right away. Now there is disagreement among libertarians about whether we should have a criminal system at all, or whether we should get rid of the criminal system, and have everything be handled by tort and by restitution. I tend to think that myself. Almost the other way, though. I think that we should get rid of all non-criminal law and everything is criminal law. That is, the whole purpose of law is to settle disputes and to determine who the owner of a resource is. And in the case of a crime, that means someone has violated the borders of someone's owned resource, and the victim now has some response that they are entitled to, some kind of punishment or some kind of restitution. My personal view is that there is as I argue in my book, in I think chapter 5, my estoppel theory, I think that when someone commits an act of aggression, violent aggression, like an act of murder or serious assault and battery, that they have forfeited part of their rights to complain about being punished. So I think in principle, punishment is justified. But I think in practice, it would be very, very rarely resorted to in society in an institutionalized way, for reasons that the more pacifist and the more anti-punishment types have pointed out, like say Randy Barnett in his book The Structure of Liberty and other theorists, because punishment, number one, is very expensive because you have to have a high burden of proof, and if you're wrong, then whoever does the punishment is now liable for harming the rights of the victim, of the innocent victim who was punished wrongly, and it doesn't actually help the victim of a crime to punish the aggressor. It's better if they get some kind of restitution, and if the aggressor has a way to apologize, make amends, make some kind of compensation or restitution to the victim, and work their way back into society. That would keep them from having to go to prisons. And if someone refuses to cooperate, then I think ostracism and being unable to participate in the benefits of being in society would be a strong way to handle crime. Now, and again, we're imagining a more peaceful society because it's already going to be a more libertarian society. So there's be far fewer crimes because most people would not voluntarily be willing to commit crimes, and we'd be richer, so there'd be less need to commit crime, and there'd be fewer actual crimes on the books because all these fake crimes would be taken off the books.
A lot of what you're touching on there actually kind of reminds me of another point I was wondering about as well. This might seem like something of a trivial issue to some people, but it is one that I think is kind of an important concept that in a libertarian society we would have to come face to face with, which is that if I initiated force against somebody, let's say it was a long time ago, and they've seek to initiate force against me in turn. Would I still be able to claim any legitimate legal ground to stand on? If I say that it's wrong of them to use force because I did use force against them. However, in this case, let's say it was a very long time ago. If it was what are the specifics in that particular case?
So I think we can imagine a couple ways, and I think the way that the legal systems have dealt with these things is instructive as to probably what would happen. So first of all, in today's legal system, and for centuries, there has been the idea that okay, you have the right to defend yourself, like in an actual attack. You don't have to like call the cops and wait. In an emergency, you can defend yourself. That's called self-help because there's no other choice. But by and large, we discourage self-help or being a vigilante or being an advocate in your own case because people have bias and they might overpunish. So there would tend to be a discouragement for people to do this. And to the extent in a private system that I'm imagining, so there would be a strong societal and legal incentive to use the existing private legal system in the case of a dispute when you can. I mean, not during an emergency. And people that don't do that are going to tend to be seen as outlaws and dangerous, and they might lose their insurance protection. Their neighbors might shun them. They might be seen as loose cannons. And as part of that way I see law developing, and which it has developed in the past, there's also going to be something like a statute of limitations, not by a statute because there would be no legislatures, but there would be rules of justice would develop. I mean, you mentioned estoppel, which is this common law principle and a Roman law principle where it's a principle of equity, where it's just unfair to let someone stand upon their rights when it contradicts what they have done in the past and what they led the other guy to rely on. There's a corresponding principle of equity called laches, which means if you wait too long to bring your suit, it's just unfair. And I think something like that, which underlies the reasoning behind the statute of limitations, is just the recognition that, well, you have to act reasonably to pursue your claim. And if you wait too long, it can be unfair to the legal system and the community because now if it's 30 years ago, the witnesses might be dead, the evidence is stale. It's harder and harder to prove your case. And why should the legal community invest their legal resources to defend your right to avenge something that happened 30 years ago when you had the opportunity to do it for the last 10, 20, 30 years. So I think at a certain point in time, you would be looked at like if the legal system says, listen, you waited too long, it's too late. But then if you went ahead and enforced your rights as a vigilante, now you're violating the other rule against self-help, and you might be looked at as an outcast. Your insurance rates might go up. You might be ejected from society that way. So I do think that there's a natural, and not only that, it's just going to be physically hard, even if you didn't have any statute of limitations. It's just as a matter of fact, it's harder to prove your case at a certain point in time. Very similar to the idea of property rights in land. I mean, lots of people say, oh, libertarianism has this rosy, idealistic view that Adam's descendants went out and they homesteaded virgin land and you can trace your title back to Adam. But that's never the case because the world has been full of conquest and theft and all this stuff. So basically, this is an argument that you don't have absolute property rights because there was theft in the chain of title somewhere in the past. And so basically you can't complain if the government takes it from you. It's really just a justification for the government taking it from you. Of course, it's a contradictory argument. It's a hypocritical argument because the government is saying you don't have a property right in this land because you can't trace your title back to Adam. So we're the owner. Well, but they can't trace their title back to Adam either. So what the legal system would do, what the libertarian approach would be, is that you only have to trace your title back to. Property titles are going to be secure unless there's a dispute. When there's a dispute between two or more people. Usually the one that's currently possessing the land under color of legal title, and the other guy who says, I'm the real owner. Okay. in such a dispute, you don't need to trace your title back to Adam. You only need to trace your title back to what we call a common ancestor in title. So if you both agree that, okay, 300 years ago it was owned by Mr. Robinson, it doesn't matter if Mr. Robinson had good title. He might have stolen it from someone before him. But if these two guys chase their title back to Mr. Robinson, now they can look at the records and see, okay, well then who's the owner of it based upon there. And if the current possessor can show he has a chain of title all the way back to Mr. Robinson, the other guy's going to have to show, well, one of your ancestors in title gave it to my uncle or something like that, and maybe the title will be transferred. But it's simple. You don't have to go back to Adam, is my point. But that's the point. Evidence is too stale. We don't know who, we don't know what the Etruscans did in Italy, 2,500 years ago. It doesn't matter, because everyone claiming ownership or the right to possess a resource now that's under dispute has to have a basis for saying I have the right to it. And the adage in the law that possession is 9/10 of the law is perfectly reasonable. It means that the presumptive owner is the one who owns it now and who has color of title, unless someone can show, for example, if some African slave can show that some white guy in Louisiana owns a plantation that was effectively stolen from his ancestor 5-7 generations ago, if he can prove it, maybe he should get the plantation back. Okay, but it's just going to be harder and harder to prove over time when records are the Israel situation is like that. I mean, you can't go 2,000 years in the past when there's not individual owners, all this kind of stuff. Which, by the way, is why I think in any developed peaceful society with property rights being respected, people would tend to have insurance, including property title insurance. So, which is what they do now, by the way. If I buy a home from you, and I pay you money for it, I want to make sure that I'm going to be secure in my title. So I pay a title insurance company to do a record search. They usually trace it back to the beginning of the state, like Texas or Louisiana, because we have a positive legal system. But the point is, they have title insurance, and the title insurance company is not going to give you a title policy unless they can make sure that there's no cloud on the title anywhere. And I think similarly in a free society, people would do the same thing. So I would buy this plantation from some guy, and I would have a title insurance policy. And if some guy comes out of the woodwork and says, oh, I have a better claim to this because your ancestor stole it from my ancestor, okay, he might win. And then the title insurance company has to pay me to compensate me. It would be, an easy solution. But of course, the incentive for the insurance company is to do a good title search. And if they find that there's a possible claim lying out there, they're going to insist that you get it cured before they give you a title policy. So over time, people would negotiate, compromise, and the records or the property titles to property, especially for land, would become clearer and clearer and clearer over time. There'd be a lower chance of someone disturbing your title to it.
As a general rule of thumb, it's obviously better to strike while the iron is hot, and naturally in terms of the burden of proof, that tends to fall on the external party anyway, the party who is not the presumptive owner at the time. And naturally, if somebody's going to claim some type of aggression being done against them, they're essentially doing themselves a disservice by allowing more and more time to lapse, because that makes their own case much harder to prove.
Yeah, and not only that, if we imagine that we probably would have a jury type of system, which you can imagine could emerge, your fellow citizens are going to be called upon to be jurors and to also help support your claim to your rights so that you're secure in your rights when you get a judgment in your favor. But let's suppose you have a neighbor who is just a pain, and he goes around suing people all the time for very trivial things. He's putting a burden on the private legal system. He's causing inconvenience to his neighbors. At a certain point in time, people are going to throw their hands up and say, listen, we're not going to waste our time on things you can solve on your own by just being more reasonable. And I think the same thing would happen with someone who waits 35 years to bring a suit. Everyone's going to go, listen, you had your chance, buddy. So I think it's going to be harder and harder to do these things. But you don't need, it's the natural aspect of the situation. You don't need to sit down in your armchair as an armchair theorist and come up with a deduced rule for this, or you don't need legislation to solve this. These problems will naturally solve themselves. In fact, people have an incentive to, like you say, strike while the iron's hot.
Also, on another note, if we start applying this similar principle towards, business, for example, as somebody who is particularly interested in how the law relates to business and entrepreneurial interests, I do follow along with how our current legal system tends to approach different business formations, whether we're talking about a sole proprietorship, a partnership, or the often maligned corporations. And I do know that you've spoken on corporations, and I would say the more important central issue there, the corporate form and how that functions under the law. So I also know that you've addressed limited liability under the law as well. So I'm kind of curious exactly what is wrong with the state's legal approach to businesses, to corporations, and how could libertarian law improve upon it?
This is actually something that most people misunderstand, just like they misunderstand intellectual property, because it's an arcane area. And even libertarians tend to be very confused about business forms like the corporation. They almost get it exactly backwards. So there's a lot of criticism of corporations, especially now. They criticize the actual corporations we have because they're part of crony capitalism, or as Gene Epstein calls it, crapitalism. And so they actually, and they hate the big tech companies now because they're kind of lefty and all this kind of stuff. So they're looking for excuses to attack the corporate form. And part of their argument is that, and a lot of left libertarians think this too, because they hate capitalism and they hate hierarchies and they hate modern American businesses. And by the way, when people talk about businesses or capitalism, or even the firm as an economic concept, they often use corporation as sort of a stand-in for that. But there are types of business organizations. There's partnerships, and there's limited liability partnerships, and there's co-ops. There's various types of organizations. The corporation is just sort of the most common one. The criticism by some libertarians is that they think that corporations have a privilege granted by the state, which is artificial, and gives it sort of like the government gives people patent and copyrights now, which is an artificial privilege, which is correct. That is an artificial privilege that they should not be granted. But they think that corporations have a privilege in the grant of limited liability because. Well, and the reason is because I think that the presupposition is that absent this grant of limited liability, shareholders would be liable for the debts of the firm. Okay, that's where I think they're wrong. In fact, it's the other way around. The state granted corporate status as an excuse to treat it like a legal person so that it can separately tax it and regulate it. So it would be better if the state stayed out of it and there was no such thing as a state-granted corporate charter. But where the opponents of corporations are wrong is they think that this would mean the end of corporations, because they think that then the shareholders would be subject to unlimited liability for the debts and torts of the employees of the corporation. But that's where they're wrong. They're wrong because they don't have a sophisticated understanding of causation and responsibility. The basic default libertarian position and the basic default position of any private legal system is that everyone is responsible for their own actions. No one is responsible for the actions of someone else. That's called vicarious liability, unless there's a reason to hold them responsible for it. So I might be responsible for my child's torts because I control him and I'm his guardian until he's an adult. Or there's some arguments, if I own my dog and my dog runs free, or if my car falls down a hill and hits someone, it's my property. There are debates about that, but the point is there's a reason to hold you liable for the actions of someone else. If there's not, then you're not liable for someone else's actions. The reason that people think that shareholders should be liable for the actions of employees of their corporation is because they mistakenly accept the statist assumptions of the state itself, which is the state classifies people that are workers of a firm, which we call a corporation, they classify them as employees. Now that's not a distinction in economics or in natural law or in nature. It's just a distinction the state comes up with as a way to regulate and to give employees certain rights, right? Certain welfare rights. So there's no such thing objectively as an employee. And also because the state calls shareholders owners of the corporation. Well, just because the state calls someone an owner doesn't mean, and this is the other mistake, people think that ownership means responsibility. Ownership does not mean responsibility. Ownership means the right to use a resource, which means the right to stop someone else from using it. If I own my body, it means that I can stop someone from using it without my permission. If I own my car, it means I can stop someone from using it without permission. It doesn't necessarily mean that I'm responsible for it. What I'm responsible for is my actions, right? So as an example, if someone steals my gun and they use it to shoot an innocent person, I have the right to use the gun, but it's been stolen from me. I didn't commit the action of murder, so I'm not responsible for it, even though my gun was used. By the same token, the murderer wasn't using a gun he owned. He was using my gun. He's still responsible because he committed the action. So responsibility comes from actions, not from ownership. So this is the mistake people make. They think that if you're the owner of something, it means you're responsible. So if I haven't, but owning something only is the right to use it or to stop people from using it. So if I'm called the owner of a corporation, it simply means I have a claim on the assets owned by that corporation. But that right to use those assets is determined by the corporate charter, which radically limits my ability to, like, if I'm a Google shareholder, I can't go to the Google headquarters and have a birthday party. I can't use the Google jet. In a sense, the managers are the real owners on a day-to-day basis. It's by a complicated contract, but the contract just specifies who the owners of resources are. But it still doesn't mean that shareholders are in any special position that they're responsible for the negligent actions of employees, which are just people that work for, that economically benefit and being paid a salary by the firm. I mean, what if the corporation doesn't have employees that are delivery drivers, but it uses FedEx? It outsources it, and FedEx commits a tort. What's the difference economically? There's no difference. So the point is that in a libertarian society, there would be no vicarious responsibility of shareholders for the torts of other people because they didn't order them to be committed. The managers might be responsible because the managers direct the boss of the delivery driver. If he told him to do something that harms someone, maybe the manager would be liable, maybe the board of directors. But by the way, board members and some manager employees, they're covered by D&O insurance, liability insurance, directors and officers liability insurance because of that risk, because they do have an active role in the management of the corporation or the firm or the partnership, whatever it is. But the shareholders are just people that have a voting right and that maybe gave money to the corporation as an investor when they purchased the shares. Right. That is not directing the actions of the employees. Now, if you have an active shareholder who's also on the board and plays an outsized role, they might be liable, but it's not because they're a shareholder. It's because they played an active role in causing one of the employees to commit a tort. So this is the flaw behind the entire idea. So I say get rid of the corporate form, and then there would be no double taxation of shareholders of these corporations. They could have they wouldn't need the protection of limited liability because shareholders shouldn't be liable anyway.
I mean, just basically, I think a lot of this misconception can be overcome if people realize that a corporation is really just a large bundle of individuals at the end of the day. We should really keep the effects of any aggressions specifically on the individuals rather than trying to spread them onto the corporation as a whole. And I feel like there's a significant tendency to do that within the larger cases.
I totally agree. And, but again, the corporate form muddies the issue because it leads people to think that it's a privilege grant. And because the state's argument is that, we need corporations to be efficiently organized and we need capitalism and all this kind of stuff. And if we don't grant this limited liability grant, then people wouldn't pool their capital and risk it and have these great things. But now we have to regulate these corporations, right? So they can't complain about there being double taxation because it is a legal person. But, there's a good book on this by Robert Hessen. It's probably the premier book. And Robert Hessen and Roger Pilon, a scholar with the Cato Institute that I mentioned earlier regarding Alan Gewerf's theory, and Rothbard, all three of these guys reject the idea of vicarious responsibility, which is called in the law respondeat superior. The idea that the master is necessarily responsible for the harms of his servants. This is an idea from slavery and from the feudal law, where people basically had servants or slaves that they basically owned or controlled, and the idea is that the master is liable for the torts of their servants. Sort of like most people would say you should be responsible for the torts of your children because you're their guardian. But in a society where people are adults and they're responsible for their own actions, and when you disregard the employee distinction, which is an artificial classification imposed by the state just to regulate capitalism and business, then again, it's not sufficient to say you should be responsible for the torts committed by this guy just because you have a voting right in the corporation, which is or the right to receive money in a dividend. That's basically the only rights of shareholders, is they have a right to receive a dividend if it's ever paid, and the right to receive assets of the company if it ever winds up, dissolves, and the right to vote at shareholder meetings. That's basically the only right. They don't have any control over what's going on there. Any more, by the way, than a customer does. So if I go into a McDonald's and I buy a hamburger, I'm giving money to McDonald's just like the shareholder gives money to McDonald's when he buys a share. So they're both sort of enabling McDonald's to do lots of things, but they're not. If the customer's not liable, then why should the shareholder be liable? Or what about a supplier, someone who sells McDonald's potatoes? They're getting money from McDonald's. They're aiding and abetting McDonald's. So if we have too loose of a connection for causal liability that ensnares third parties to be vicariously liable for other people's actions, then we have a society where everyone's responsible for what everyone else does, unless you're a hermit. Because if I go buy a hammer from a hardware store, now I'm potentially fractionally on the hook for torts committed by that hardware store because I gave them money and I supported what they did. You have to have a good reason. Just like in criminal law, we say that you can only respond to someone with force if there's an imminent threat. It can't be just like a vague statement. So there has to be certain bright lines or certain objective criteria you use to attribute responsibility to someone for someone else's actions.
Since we've been addressing the different ways that the law approaches its property, different forms of it, my question really then is, how do you believe that the law specifically misconceives property, in regards to physical property and intellectual property, which I know is really your signature issue?
So, for example, there are some causes of action or torts under the common law that I think are incompatible with libertarianism. So, for example, defamation and even trademark law, which I can explain later, but and blackmail, the prohibition against blackmail. I think that blackmail is not a crime, and defamation is certainly not a crime. It's just free speech because no one owns a property right in their reputation. So the law got that wrong, but they got that wrong because of an unsophisticated and non-Austrian view of economics and value. So, people conflated the right to have the physical integrity of your body and your property borders defended by property. They conflated that with economic rationale and need for these things, which is that they have a value to you. So, yeah, of course, I like having a piece of land because I can use it, so I value it. It has a value to me, but of course, value is subjective, and the property rights are not in the value of the land, but that's how the law looks at it. In fact, the law almost has to look at it that way because the law is always subject to the exceptions of the state's ability to come in and make a change. So if the state wants to take my property in the form of eminent domain or condemnation, right, to make a road, in most Western legal systems, okay, the state has to pay me compensation using taxpayer funds so that the burden doesn't fall just on me. So they take my house and they have to give me compensation for it. Now, it still might be unjust and I might hate it, but at least the state attempts to make compensation to me. But what's the standard? I mean, what if the house to me is worth $5 million, but it's on the fair market value? The fair market value is only $1 million. The state's only going to pay me the fair market value. But of course, that's the only way they can do it because they have to come up with a number. So they say fair market value. But that's not an Austrian or libertarian concept because value is subjective, right? There is no objective value of a thing. So the state has to do this. Now, so there are some deviations, some problems with the private law, but largely I think the property law part is good, except again for this idea of a rights in your reputation, which is what underlies defamation law. In fact, I have an extensive article coming out on that topic in 2 months in a book, arguing that defamation law should be classified as a type of intellectual property, and for the same reason that intellectual property law is unjust, which I'll get to in a second, defamation law is unjust for similar reasons and should be considered to be a type of intellectual property right because it's a type of property right in an intangible thing, right? Now, the law has also, in addition to trademark, which is a type of intellectual property, which did evolve on the common law, but it's not your traditional type of intellectual property. Intellectual property is an umbrella term that is used in the legal in law to classify different types of rights having to do with usually products of the mind, like inventions, which is what patent law covers, and works of art, which is what copyright covers. It also extends to things like trade secrets and trademark. Now, trademark emerged sort of on a hybrid ground of trying to protect consumers from fraud. Now, fraud ought to be considered a tort or an offense under the law because it violates people's property rights in their property. It's a type of theft by trick is the way I talk about it. I talk about that in chapter 9 of my book. That's why fraud can be considered a type of crime because it's a type of theft by trick of someone, like using someone's property without their informed consent, you could call it. And so the idea was that if some merchant is using the mark of another merchant and it confuses the consumers, then it violates their rights because it's taking their property, their money for this product without their informed consent because they're sort of deceived about the nature of it. So you could see how trademark law would emerge as sort of a rough way of protecting the rights of consumers based upon the idea that the seller doesn't have the right to defraud them, okay? But the problem with that is that fraud is already covered by fraud law and contract law, so you don't need a special trademark right for that. What trademark evolved into was a reputation right similar to defamation law, where the first company using that mark in commerce is said to have owned the trademark to it and the goodwill associated with it. And if some competitor uses a mark that's too similar that might confuse consumers, then that competitor is not violating the rights of consumers because he's defrauding them. Instead, he's violating the trademark rights of the original company, but because they lower the value of that right. But again, property rights shouldn't be valued. So that's the problem with trademark law. It's not the most evil law, but it is turned into a reputation right, which is what defamation law protects, which it shouldn't, instead of being really about protecting consumers from fraud. Which is why when you prove a defamation, when you bring a trademark claim, you don't have to prove that the consumers were defrauded, only a likelihood of confusion. And not only that, you don't even have to prove actual confusion because let's take an example of a knockoff a company making Gucci purses, knockoff Gucci purses, selling them on out of the back of a van in New York City on the street for $10 each. The consumers are buying it to get a knockoff purse. They're not being defrauded or confused because they know that these are not real purses. They're not real Gucci's. So there's no fraud at all. But the holder of the trademark can still get a court order to have those purses seized and destroyed because of the trademark right. So that's what trademark law has metastasized into. In any case, that was a separate right under the common law, another deviation from where the common law deviates from libertarian principles, I would say. But there was also patent and copyright emerged as separate statutory schemes to protect the rights of authors and inventors. Right? Actually, they originally were the purpose of them originally was to protect inventors from competition. And not only inventors, just anyone who was getting a patent grant from the king. And in the case of copyright, it was to regulate what books could be printed, to censor freedom of the press and speech. They both evolved into statutory copyright and patent laws, which were seen originally as temporary monopoly privilege grants designed to incentivize artistic creation in the case of copyrights and invention in the case of the patent system. That was the argument given. It was a utilitarian argument. There's no evidence to back up their claims. There's never been evidence even gathered in the last 230 plus years of American patent law. But they were limited in time. Originally about 14 years each. Now patents are about 17 years, and copyrights last for over 100 years in most cases. The life of the author plus 70 years. It's insane.
Before public domain, yes.
Right. But what happened was in the 19th century. So after the U.S. was founded in 1776, 89, 1789, let's say, the Constitution, and then the next year the patent and copyright laws were enacted based upon a clause in the Constitution. Then the Industrial Revolution got underway, and then in the 1800s, the free market economists started complaining about these monopoly privilege grants of patent and copyright, which no one called intellectual property at the time. No one thought of them as property rights. They didn't think of them as natural property rights at all. They just saw them as temporary expediencies to try to stimulate innovation and creativity based upon an unproven assumption about the necessity. Again, it's the public goods idea that if you don't have it, you'll have an underproduction of artistic and creative works and inventive works. So the government needs to have these temporary incentives in the form of monopoly grants. But they were seen as privileges which were going to expire and were maybe a necessary evil. But the free market economists started waking up to how bad they were. And some countries in Europe, in the Netherlands, Switzerland, they started either abolishing their patent systems because they realized they were incompatible with free trade and with capitalism and all this kind of stuff. Unfortunately, in 1873, there was something called the Long Depression. It was actually called the Great Depression at first, but now we call it the Long Depression, and that led to a turning of public opinion against free trade because of the recession that happened, and the anti-patent movement collapsed, and then the patents gained steam again, and now we have the situation that we have now. But as part of that debate and criticism of patent and copyright by the free market economists, the defenders of these systems, which were people that were dependent upon these monopoly privilege grants, like the publishing industry and authors, inventors, certain firms, the airplane manufacturers, the cotton gin, maybe, I don't know, different people making different contraptions, where the light bulb, the movie industry, Thomas Edison, all this stuff, where they could make monopoly profits because they could stop their competitors. So they fought to preserve these things. And part of their defense was to object to the criticism of these things as being monopoly privilege grants. And they instead said, they're not monopoly privilege grants. They're natural property rights. And so they started calling them property rights. And then the free market economists said, well, what kind of property right is it that has to be granted by the legislature? And number two, that expires after 15 years or 17 years. And the response was, well, it's a special type of property right. It's an intellectual property right. So this concept of IP arose primarily to defend patent and copyright by lumping. And so they said, oh, it also includes other types of property rights like trademark. You remember trademark law? We've had that for a long time. It's just another, and trade secret law, we've had that for a long time. So you have all these types of intellectual property rights having to do with the products of the mind and intellectual creativity, like copyright and patent and trade secret and trademark law. So it's just a special type of law. So, ignore the fact that it's a monopoly privilege that restricts free speech and freedom of the press and reduces competition and gives people monopoly profits and reduces invention and innovation.
These laws function less as something that really protects people or ideas and have become more of just a minefield to navigate through. Simply because
Yes.
it's become so extensive and cumbersome.
Yes, and it causes patent attorneys like me and IP lawyers to be paid high salaries by corporations, and the corporations don't care because it actually helps. When people criticize corporations, part of the reason they're so large and they're so powerful is not because of the limited liability thing. It's because number one, they have a lot of government, military, industrial complex. They're getting funded by the government. Boeing is funded by the military for a lot of their planes and things like that. And a lot of these large corporations like Microsoft, Apple, Hollywood, the music industry, they have so much resources because of patents and copyrights, and it helps lead to monopoly. I mean, it's not surprising that monopoly privilege grants granted by the state, patent and copyright, would lead to monopolistic practices and monopolies being formed. Even though we have antitrust law, which is supposed to be against monopolies, the state wants to outlaw monopolies, and yet it grants monopoly privilege grants to corporations, and the large ones use that to accumulate, say, big war chests of patents like Apple and Motorola and these guys. And when they get these big war chests of patents, which they pay for by hiring patent lawyers to do it, and then they can charge royalties to people, or they can use this to stop competition. So, for example, there was a smartphone maybe 15 years ago, 10 years ago, there was a smartphone wars. Apple had a patent on rounded corners of a touchscreen smartphone, for example. And there was lawsuits back at hundreds of patents, and not just them, Motorola and Samsung and all. And so they sued each other, and they spent hundreds of millions of dollars on lawyer fees and lawsuits. And of course, after say 7 years, they just finally did a settlement. Like, Apple agreed to give a license to Motorola for its 500 patents, and Motorola agreed to give a license to Apple for 300 of its patents. And so now they can't sue each other, and maybe one of them paid someone a compensation or something, or a license fee. But that just means that they just raise their prices that they're charging to consumers. And it also means there's less competition. Some small guy starting a new smartphone in his garage can't make it and start selling it because he would be sued into oblivion by the big guys, because they have hundreds of patents and big lawyers, big law firms, and big legal budgets. And so they don't even bother. So it reduces innovation and competition and causes prices to be higher. And then everyone, and then the government, and then people oppose corporations because they're monopolies. Like, that's endemic to capitalism. I mean, corporations shouldn't have patents in the first place. Maybe they wouldn't be so big without these patents.
I know that large corporations love IP laws because they provide them with a type of protectionism that is very similar to occupational licensing laws as well, the state currently bestows. And one thing I found too is that a trend as far as people, criticizing intellectual property, they'll often sometimes cite an issue, but the issue won't be as a matter of aggressing against intellectual property, but more so against an adjacent issue. So, for example, if we take one where, let's say, a student plagiarizes a paper, some people will cite this one as a reason of why intellectual property is important. But I believe this issue has nothing to do with intellectual property when you get into it. The issue is a matter of the whole purpose of the assignment was for the student to demonstrate his knowledge of the subject matter, and instead he has completely done something complete. He hasn't done that. Whereas, and just to prove this case, what if the student had gotten express permission from the writer to use that submission of his work? It doesn't change the situation. It doesn't change the actual fact of the situation.
Well, no, not. I mean, so there's two types of arguments like this. One is the well-meaning but confused argument by people who just don't understand this admittedly complicated and arcane. I mean, your average layman is not going to understand the difference between patent law, copyright law, trademark law, trade secret law, fraud law, defamation law, antitrust law, and plagiarism, and they mix these things together. And then sometimes people do it dishonestly, like they sort of know they're just like they're basically being dishonest, and they'll say, well, if you're against intellectual property law, you're in favor of fraud, or you're in favor of dishonesty. It's like, well, okay, so your point is correct about plagiarism, and it's easy to see this if you just think about it. If I'm a student at a college, at a university, with a plagiarism code, if I plagiarize a, a, a poem from a book that was published 200 years ago, it's not a copyright violation, but it's still plagiarism, right? Plagiarism has literally nothing to do with. And in fact, if I publish a book on Amazon, if I publish, let's say, Moby Dick on Amazon, Moby Dick is out of copyright, I believe. It's too old. If I publish my own copy of Moby Dick on Amazon, and I put on there Herman Melville as the author, I'm not being dishonest. I'm not plagiarizing. I'm simply selling a copy of a book. It's not a copyright infringement, and it's not immoral. There's nothing wrong about it. Now, if I publish Moby Dick and I put my name on it and I pretend to be the author, it's still not a copyright infringement, but it's maybe an act of fraud or dishonesty. It's shady, and it's just stupid because no one's going to buy that book. They're going to think, what else did the guy change in the book if he's putting his name on it? I mean, but there's nothing wrong with it. There's a reason people don't sell copies of the Bible that they came up with themselves, because no one would buy it. But it's perfectly legal to do it. Well, not if it's a modern translation, it's not. But you could find an old one, right? There's a reason why people don't take Shakespeare's plays and publish them on Amazon with their name on it. I mean, maybe Amazon would stop it, but still, you could print it yourself and sell copies. But no one's going to buy Romeo and Juliet by Stephan Kinsella, because they're going to know that they know who the author was. They don't want a fake one that's adulterated. So there's really no problem here to solve. But the point is, people will say, oh, well, like for trademark, they'll say, well, if you get rid of trademark, that means you're in favor of defrauding customers. It's like, no, a trademark law is not about fraud. It's about protecting the property right and value of something, which is not a property right. Or they'll say, well, if you get rid of copyright, then you want people to just slap their name on your book. Well, that's either fraud or contract breach or plagiarism. That's got nothing to do with copyright. I guarantee that if you took a copy of J.K. Rowling's Harry Potter and you sold it on Amazon with her name on it, she would still sue you. She's not objecting to the fact that you put your name on it. She's objecting to the fact that you kept her name on it and you're selling a book that she has a copyright to. So then ultimately it comes down to, well, if you're against patents, you're against innovation. So the assumption there is that we need patents for innovation, and that's the purpose of law, is to stimulate innovation. The purpose of law is not to stimulate innovation. The purpose of law is to protect property rights and to do justice, right? And the presumption also is that without patents, the presumption is that patents are synonymous with innovation. They're not. There's lots of innovation that is not patented and not patentable, and not every patented invention is really truly an invention, or an innovation. And it's absurd to say that without patents, there would be no innovation, because there was innovation before the patent system. So at most, you could say that without patents, there's less innovation. Okay, but then that's an empirical claim, and you need proof of that, right? And you would also need another form of proof, which people they're not even aware of. People will say, well, I think that the patent system produces more innovation than there would be without a patent system. Okay, no, number one, they need evidence for this, and there is literally no evidence that any economist has been able to find in the last 150 years of looking at it. None. And I think it's the reason why is because it doesn't produce innovation, and there's no way to measure it anyway. So there is no proof that more innovation is stimulated by the patent system. But even if it was, you still need to take into account the cost of the patent system, because it has a huge cost on society. It distorts innovation. It causes higher prices. It reduces some competitors from innovating during the 17-year period of the patent. Money is spent on lawyers like me and lawsuits, and it comes from somewhere, right? There's hundreds of millions of dollars spent on legal fees alone. Okay, so there's without doubt there's a large cost to maintaining and imposing this patent system on the country and on the world. So even if you said that the patent system stimulates, let's say we have innovation at this level, because it can't be zero. Let's say it's 100, and with the patent system, let's say it's 110. Okay, but the cost is 20. So you have to prove that the cost is less than the net gains. And no one even knows what the costs are. And they don't even try to prove that. And they don't know what the net gain is. And they don't know that there is net gain. In fact, there is every reason to believe there's reduced innovation. So everything about the empirical case and the utilitarian case and the pragmatic case for patents is just wrong. Not to mention the fact that it's not the whole purpose of the law is not to have a committee of idiot congressmen who don't know anything about technology and capitalism, who are captured by special interests, right? Is to sit around and say, our job is not to monopolize the legal system or protect property rights in an inefficient and brutal way. Our job is to try to listen to special interests and economists who tell us, I've discovered a defect in capitalism. Here's a case where capitalism doesn't give us exactly the perfect optimal amount of goods. We think that there's a market failure here. There's a public goods problem. And so we think that there's on the free market, it's pretty good for making butter and guns, but it doesn't produce quite enough artistic works and innovation. So there's an underproduction of innovation because of free rider problems and holdout problems and all these market failures. So the government's going to come in and we're going to keep the capitalist system from having an underproduction of innovative goods. We're going to bump it up a little bit by giving these suppliers a little patch on the system called patent and copyright law. Now, how they know that this actually patch is necessary or does what they claim it does when they have no empirical evidence for it and their logic makes no sense. This is the reason why libertarians ought to universally be opposed to patent and copyright. Unfortunately, a large number of libertarians, less now than when I started writing on this 20 plus years ago, but this is why libertarians are wrong about patent and copyright, because they have a confusion about the basis of property rights. Because and I think ultimately it's because of a mistake that crept into political philosophy from some of the early reasoning of John Locke, which was his argument in defense of property rights and the right to homestead unowned resources. His argument relied upon,
the three methods of creating property. I don't mean to interrupt you there, but I just meant that, if I'm not mistaken, John Locke laid out multiple forms of establishing property, and if I'm not mistaken, creation was one of them.
Yes, and the mistake about, and a lot of modern libertarians say this too. They'll say creation is a source of property rights, and that's wrong. That's their mistake. As I mentioned earlier, the only source of property rights in external resources is, number one, homesteading an unowned resource, or two, acquiring it by contract from a previous owner. That's it. Creation is not a source of rights or property rights. Creation is a source of wealth. What creation means is transforming an owned resource into a more useful pattern or arrangement or configuration. That's what production is, right? It's useful. It's valuable. It produces wealth. In other words, if I have some raw materials that I owned because I bought it from someone by contract, or I homesteaded it from the woods, from the forest, if I transform this raw material, let's say, into a cabin or into a plow, I have made the thing I own more valuable. I've rearranged it, so I've increased my wealth, but I haven't increased my property rights. I already had to have a property right in the thing to own it. This is the fundamental mistake. And Locke's mistake was he was trying to justify the right to, why you have a right to be the owner of a thing you homesteaded. And he's correct that you do have that right, but it's only because you're the first one to do it and you could establish a connection between you and the thing, which gives you a better claim than anyone else. But that argument doesn't require you to make the extra step, which he did, of saying the reason you own it is because you own yourself, and therefore you own your labor, and therefore you own things you mix your labor with. That's the fatal flaw in Locke's reasoning, which you can take out and the argument still works. But when you keep that step in, people start thinking that they start thinking of labor as a substance that is owned, which is why this term, if you're against patents, you're against people owning the fruits of their labor. So they're arguing by metaphor. Fruit is actually a metaphor for, the word fruit comes from actual fruit of a tree, and it's the idea, or an animal's offspring, like a calf of a cow is called the fruit of the calf. It's called, or if you make interest on a loan, that's called civil fruits. These are all metaphors we're using to explain why people, if you have a tree and it grows fruit, you own it because your tree produced it. Or if you have a cow, you own the calf it gives birth to because you own the cow already. Or if you own money and you have the right to earn interest on it or rent on an apartment that you rent to someone because you own it, right? None of these things are really proof that you have a property right in the fruit of your labor. It just means that if you own a thing, you have the right to use it however you see fit. And if you can make a profit out of it, go ahead. But it doesn't mean you have the right to the fruits of your labor. So anyway, this whole idea of labor is mistaken and has corrupted. And so even today, libertarians will say, well, you have the right to a novel because you created it. So they're just automatically assuming that creation is a source of property rights. But it's not. And you can easily see this because if I'm a worker on Henry Ford's assembly line making Model T cars, I am producing those cars, but I'm using someone else's property to do it under a contract where I'm not entitled to the cars or to the profit. I'm only entitled to a wage. It's just a contract. In fact, this is why I think Locke's labor theory of property led to the labor theory of value of Smith and Ricardo, and then later Karl Marx, which is why they think workers are exploited if the employer makes a profit. Because if the employer makes a profit, that means he's stealing the labor value, surplus labor value of the employees, because they're thinking of labor as a substance emanating from your body that you own because of this fundamental mistake. So this is the mistake of libertarians who adamantly say, well, they're mistaken empirically about the need for patent and copyright to stimulate artistic creation and innovation. They're just wrong as an empirical matter about that. But they're also wrong that creation is a source of rights and that you own what you create. You don't own what you create. If you create something with someone else's resources, they own it unless you had a contract, right? If you steal someone's hunk of marble, and you make a statue, you made the statue, but you use someone else's property. If I use Henry Ford's raw materials to make a car, I don't own the car that comes out, even though I made it. Creation is not a source of ownership at all. So this idea that if I create the book or the poem or the invention, I should own it because I created it, that's never a source of property rights in the first place. So that's ultimately the fundamental mistake. And if you have a clear understanding of these property rights rules and of what scarcity is and the need for property rights, which is a response to the fundamental fact of scarcity and the possibility of conflict in this world we live in, then it's harder to make that mistake. You understand the difference between a property right in the physical integrity of a resource that you acquired by contract or from the state of nature. And then you understand why these mistakes people make, like a property right in the value of something. No, you don't have a property right in value of things. That's why defamation law is wrong and why trademark law is wrong. No, you don't have a property right in your labor because labor is not an ownable thing. Labor is an action you perform using the body that you own. And by the way, labor is just one of two types of action, right? Economists break action down into two types of action, labor and leisure, just like we have capital goods and consumer goods. Capital goods are there just as a means to produce consumer goods. Consumer goods are things that we ultimately consume to satisfy our goals, right? Our desires and our needs. Likewise, there's leisure and labor. We engage in labor for a longer term goal, like to produce the leisure that we want, right? But they're both just two types of action. When I'm moving around the world doing something with my body, I'm either engaging in leisure or I'm engaging in labor, just like there's either a capital good or a consumer good. But they're both just types of action. Just like it's nonsensical to say It's that you own your leisure. What does that even mean? I own my body and I own my leisure. What does that even mean? That's nonsensical and it's wrong. By the same token, it's also is exactly nonsensical to say that you own your labor. They're both just types of action. You don't own your actions. You don't own your labor. You don't own your leisure. You don't own the fruits of your labor. These are all metaphors and they're wrong. So this is the fundamental mistake of political philosophy, and it's contaminated even libertarian theory because of the influence of people like Ayn Rand and Galambos and utilitarians and the founding fathers who put the patent and copyright clause in the Constitution. And it should be jettisoned, and we should have a cleaner, more propertarian set of libertarian principles, in my opinion.
Semantics have really poisoned the whole concept behind, what constitutes property and what does not. Now, I do know that we are running low on time here, so in that case, I just want to ask you one final question. Just looking forward, what is your prediction for the future in regards to these IP laws, considering how they currently exist in the United States?
There's been, for decades, there's been continual agitation on the parts of IP holders to strengthen the laws, and America has used its power to engage in what I call IP imperialism to make other countries adopt more draconian laws similar to ours. This process, I would say, accelerated after the internet made piracy more powerful. Piracy more widespread. But in recent years, I think it's gotten harder and harder to expand IP much more. The copyright term used to be 14 years, like extendable to 28 years once, and then it went to a higher term. Then it went to life of the author plus 50 years. Then 20 years was tacked on about 15, 20 years ago when Mickey Mouse copyright was about to expire under the Sonny Bono Copyright Term Extension Act. And there's been agitation to do it again, but I think they're done. I don't think they can go any further. I don't think they can extend copyright much further. I don't see copyright terms ever getting longer. Patent terms I don't think will ever get longer. But I don't think these laws will ever be repealed because people just don't understand this and there's too many entrenched interests. What I do see, however, is the ability of technology, thankfully, to allow people to evade these laws. It's already happening in the case of copyright because it's almost impossible to stop piracy of books and movies and music on the internet, which is a good thing. Patents, I believe the one hope we have for patents is that eventually 3D printing will become a very mature technology. I think we're a long way away from that. Like when you can print an iPhone, let's say, something advanced with a 3D printer. I mean, you can imagine that in 50 years or 30 years maybe, but not for a while. But eventually 3D printing hopefully will become advanced enough where people will have 3D printers available to them, say in their basement, and then they can download a file on the dark web or encrypted on the internet somewhere that's got the schematics for a device, and they can just print it out and make it without any patent holder being able to stop them. So I think technology is our only hope to get around these laws.
Technology definitely seems to hold a key in overcoming these IP laws, whether it's, like you're saying, through the independent production of 3D materials, or perhaps through AI's current, evolution as we see it.
Now, the one thing I would say is I think that when copyright law has a more noticeable effect on culture and on technology, that's when the average person and business kind of gets annoyed by it. I mean, the software industry has already gone open source for decades now because they don't see the point of copyright for a lot of software. But I believe that just like copyright strangled this Google print, I mean, there's a Google print project, but it sort of didn't go where you wanted to go because of all the copyright lawsuits. And only Google was rich enough to kind of try to do something in that regard. I do think that there's a big looming threat to AI development because of copyright. Because the only way to train a lot of these large language models is to get tons and tons and tons of data, right? To slowly train the model. And of course, you have to do that by scraping copyrighted material off of books and the internet and things like that. And there's already lawsuits starting from these, people claiming that their music or their song or their books are being used for training purposes. And so that could definitely distort and stunt the development of AI. I don't know what the solution to that's going to be. Ideally, it would be good if Congress would pass a law making a fair use exception to the copyright law so it doesn't do that. But I really doubt they would do something so sensible because they have the IP mentality. But maybe there's some chance of that, or maybe some court will rule that it's fair use to train and it's not copyright infringement. That might be good, but the court could rule the other way. We don't know.
Now, with that said, though, I do want to thank you, Stephan, for appearing on the show. And thanks to everybody for listening in. This has been Morgan Meets the Eye. Make sure to follow Stephan Kinsella, subscribe, comment, and above all, keep asking why. Everybody out there, have a good one. Bye-bye.